Why is challenging hearsay so difficult for a jury to grasp? Imagine sitting in a courtroom hearing someone say, "I heard from my friend that the defendant was at the scene." It sounds simple, but it's actually quite tricky for a jury to understand why that kind of statement can be problematic. Hearsay involves statements made outside the courtroom by someone not testifying, and they are offered to prove what was said or what actually happened. The challenge is that jurors aren't used to evaluating information that they didn't see or hear firsthand. They can't ask the original speaker questions or see their reactions, which makes it hard to judge if the statement is trustworthy. Jurors naturally want to consider all the information they hear, but hearsay is usually not allowed because it lacks the safeguards of live testimony. For example, if a witness says, "Sarah told me she saw the defendant at the scene," the jury hears a second-hand account. They don't get to see Sarah or hear her tell her story directly. This makes it difficult for jurors to assess her honesty, perception, or memory. Without that direct connection, they might find it hard to decide if the statement is reliable or just hearsay that should be ignored. The rules about hearsay are quite detailed. The law generally says hearsay is not allowed unless it fits into certain exceptions. These exceptions include situations where the statement was made under specific circumstances, like during a declaration of intent or a spontaneous statement. Jurors need to understand these rules and when hearsay can be admitted, but that's not easy without legal training. The rules are complex, and they often involve layers of statements, called double hearsay, where one hearsay contains another hearsay. Each layer has to meet certain standards, which adds to the confusion. Judges try to help jurors by giving instructions about hearsay, explaining that they should not consider inadmissible hearsay as proof of the facts. But even with these instructions, jurors can struggle. They might confuse hearsay with direct evidence or give it more weight because it sounds convincing. Sometimes hearsay fills in gaps in the story, making it seem more complete, even though it's not reliable. During the trial, attorneys have to object to hearsay and explain why a statement shouldn't be considered. Jurors then need to pay close attention to the judge's instructions and understand the reasons behind excluding certain evidence. This process is tough because it asks jurors to apply abstract legal rules to what they hear, rather than simply judging the facts. In the end, the difficulty in understanding and challenging hearsay comes down to its indirect nature, the complicated legal rules, and the fact that jurors cannot see or hear the original speaker directly. They have to rely on instructions and their judgment about whether the evidence is trustworthy. This makes hearsay one of the more complicated types of evidence for jurors to evaluate accurately.